Hello and welcome to our first short video on the upcoming changes to the data protection laws. I'm going to concentrate on the changes you need to be looking at right now and what we can do to help make sure that you can comply when it comes into force in early 2018. While you are planning these changes, you need to be aware that the Data Protection Act 1998 remains in force until May 2018, and so it is important that you still comply with its requirements until this date. The replacement legislation derives from Europe and is called the General Data Protection Regulation, which I will refer to as the GDPR. This legislation will automatically become law in the UK on the 25th of May 2018. Since all organisations processing personal data must be compliant by this date, planning now for what your organisation needs to do to ensure compliance with the new legislation is vital. I want to take you through 9 steps that should concentrate your thinking in order to start preparing for the new GDPR. I shall assume that terms like personal data are known to you. If not, please see our blog on our website. The first step towards compliance is to identify exactly what personal information your organisation is processing. If you have good information management systems in place, then this may be a very straightforward process for you to carry out. If you do not have a full overview of all the personal information that you hold, then you should carry out a full audit of all your files, both electronic and manual. You will need to identify what information you hold, where it came from and who you share it with. There are helpful guides on how to do this on the Information Commissioner's website. Organisations can only process personal data where they have a legal basis for doing so. For some organisations, this may be in order to fulfil legal obligations, and for others, it may be necessary to comply with a contract that the organisation has entered into with the individual. In many cases, an organisation relies on the consent of the individual. These conditions have broadly remained the same. However, they are more prescriptive, and in particular, the rules regarding consent are now stricter. Accordingly, when carrying out an audit of personal data, you need to consider the legal basis for processing and document the reasons. On the issue of consent, you need to decide whether your organisation still has consent to process the personal information. The requirements of consent are stricter, and consent under the GDPR must be freely given, specific, informed and unambiguous. In order to achieve this, your organisation needs to be reviewing how it obtained consent from the individual, the specific wording used and how you record this consent. One of the main methods that your organisation will use to communicate information to an individual is via privacy notices and policies, which will be contained on your website and on paper forms. All forms, whether paper or electronic, should contain a privacy notice that is available at the point where the information is collected. Your organisation should also have a more detailed privacy policy on its website. These notices all need to be reviewed to ensure that they are drafted in clear and plain language. The use of pre-tick boxes will no longer be considered to be valid consent, neither will inactivity or silence. The GDPR will also require organisations to give more information to individuals about their rights in relation to their personal data, and this needs to be included in the privacy policy. The GDPR returns the right for an individual to access their own data, which was commonly referred to as a subject access request under the Data Protection Act. However, organisations will now have to comply with a subject access request within 1 month, and a charge can only be made where a person asks for additional copies of the information. Organisations need to be checking their procedures now to ensure that they can comply with the shorter timescales. The GDPR also contains the right to rectification, otherwise known as the right to object. This allows an individual to tell an organisation to correct errors in personal data that it is processing. There is also the right of erasure, known as the right to be forgotten. This is where an individual can require an organisation to delete his or her data where it is no longer required or where they have withdrawn their consent for processing. This could be a problem for some organisations as this data must be permanently erased. The right of data portability is a right to receive the information in a commonly used machine-readable format and for one data controller to directly transfer it to another. The European Commission and national data protection authorities are aware that these rights could cause issues, especially for small and medium-sized businesses, and they are currently working on guidance to assist them to comply. Organisations need to be implementing training for all staff who process personal information. Staff need to be aware of the changes to the law and in particular the changes to consent, how to recognise and deal with a subject access request within the new timescales, and also what to do if there is a security breach. This is particularly important given that the fines under the new legislation are very high and could be up to 4% of annual worldwide turnover or a maximum of €20 million. All organisations need to have a procedure in place to detect, deal with and, if necessary, report any data security breaches. The requirement to report a data security breach will apply to all organisations from July 2018. An organisation will be required to report a data security breach to the Information Commissioner's Office within 72 hours of the breach, and the notification must include the details of the breach and the scale of it, for example, how many individuals may be affected. The requirement to report the breach only applies if the breach results in a risk to an individual, and this is a risk of things such as physical, material or non-material damage, discrimination, identity theft, fraud, financial loss, loss of confidentiality, or preventing a data subject from exercising control over their own personal data. All organisations will be expected to consider data protection from day one of any project which affects the processing of personal data. So, for example, this could be implementing a new IT system or changes to your staffing, and carrying out a data protection impact assessment will be part of this process. The GDPR allows organisations to consider the cost of technology required and the cost of implementing it in relation to the nature, scope and purpose of the processing, as well as the risks to individuals. Any organisation whose core activities consist of the regular and systematic monitoring of data subjects on a large scale, or where they process special categories of data on a large scale, more commonly known as sensitive personal data, then the organisation will require a data protection officer. So you should be thinking about this now, as it is estimated that 28,000 data protection officers will be required across Europe by 2018. The data protection officer must be an expert in data protection law and can either be an employee or a contractor. I suppose there are 2 points of good news. The first is that if you implemented all of these steps now, you will still be in compliance with the Data Protection Act. And the second piece of good news is that notification to the Information Commissioner's Office is abolished, so you will no longer need to pay the annual fee. Whilst we are expecting guidance from Europe and from the Information Commissioner's Office over the next 12 to 18 months, the steps that we have highlighted can all be started now, and we are here to help. If you would like advice on how we can work with your organisation, please contact me. My details are on the screen. I look forward to hearing from you.